Welcome to today's webinar, Navigating APAC Data Privacy Laws, Compliance and Challenges. As you can see here, we do have a lot for you here today, covering a wide range of things you need to know about data privacy laws in the APAC region, including diving into what regulators are focusing on and how certifications are a critical tool in your organization's data protection toolkit, especially as it comes with for data transfers, and then how the DOJ rules impact data transfers. To kick things off, to turn things over to Josh, who is going to give us an update on the different laws in the APAC region, where things are at, where they're heading. And then we'll go into some of the regulatory concerns. So, Josh, what is happening in APAC in terms of all the different laws?
Thank you so much, Joanne, and thanks for passing the time over to me. It's really a great pleasure to be speaking at today's Trust Arc APAC Laws webinar for 2025 to kind of just share what the landscape for data protection laws looks like at the moment in APAC and what are the issues that is top of mind for regulators. So we'll see today's presentation in two halves. We'll start with overall coverage of the data protection laws in APAC. Then we'll move on to the regulators' priorities. Following that, we'll just touch a bit on what organizations can potentially do in this part of the world, and then look at potentially what are some of the issues that are coming up in the rest of 2025 as well. So with that, let's get started. Thank you very much. So let's start by having a brief overview of the data protection landscape in the APAC region. This region is one of the most, if not the most diverse region in the world in terms of languages, cultures, and legal systems. Interestingly, though, notwithstanding that diversity, most major jurisdictions in the region now have comprehensive national data protection frameworks or regulatory regimes. And the development of these laws reflects three distinct waves of regulatory evolution across the region. If you look at this map here, you will see that the first generation emerged in the late 1980s and 1990s and includes the data protection laws of Australia, New Zealand, and Hong Kong. Many of these laws were based on the 1980 OECD guidelines on the protection of privacy and trans-border flows of personal data. The second wave appeared in the 2000s and early 2010s, and it includes the data protection laws of Japan, South Korea, Malaysia, Singapore. This generation is characterized by a diversity of different approaches to data protection. But we also see the influence of European body of data protection law emerging in this region, as seen in Macau and South Korea. Then the third and most recent wave of new data protection laws followed the enactment of the GDPR in the EU. And this includes the data protection laws of Thailand, China, Indonesia, most recently India. And I saw from the polls earlier that the jurisdictions that actually had the most attention with regard to data protection were China and India, followed by Japan. So for China and India, they fall within this third wave of data protection laws. Now, not all of these laws are operational yet, and some, like those in Indonesia and India, are still being implemented. At the same time, the data protection landscape in this region is highly dynamic. Several jurisdictions are modernizing actively their regulatory frameworks to ensure that they remain effective in addressing emerging technological challenges and facilitating digital innovation. So, just to draw some examples, last year, Australia enacted the first of two tranches of amendments to its Privacy Act following a comprehensive multi-year review. And we're waiting for news on the second tranche of amendments to be coming to come about. The good thing is that the present administration has remained in place. So it's likely that they will continue to push on with their regulatory agenda on this front. Malaysia
Yeah.
also updated its law in mid-2024. Joanne, you had a question.
Oh, yeah. No, you read my mind, Josh. I think one of the biggest things that we are seeing in terms of a trend is that, especially the jurisdictions that have had older laws, are starting to make updates, and we're starting to see a lot more amendments. Because Japan also had updated its APPI not too long ago as well. and they're pretty.
Yes, and it's in the midst of reviewing the APPI too. So we might see
Yeah.
amendments coming into effect in 2026. South Korea is the one that has been actively revamping its data protection framework, right? They had amendments in 2023. And in fact, they are now considering a further amendment to add a new legal basis called a public interest basis to allow organizations to use data that they already have collected for AI training purposes that is in the public's interest. So that needs to be checked by the regulator, but I don't want to go too deep into that. Looking ahead, as I mentioned, Japan, Hong Kong, Taiwan, they're also looking to amend their respective frameworks. And then last but certainly not least, new data protection laws are still coming about. For example, just today, Vietnam's National Assembly approved the Personal Data Protection Law. So there's a whole new framework that just came up in Vietnam today. And that goes to show the amount of dynamism and activity that we're seeing in this region. Now, to drive home the point, Maria, I'll ask you to go to the next slide. This slide is something that I would describe to you in a sentence as this will definitely keep all lawyers busy because there's just simply so much activity that is going on. And I'm merely talking about cross-border data transfers. I think it kind of epitomizes, the diversity in this region. And again, I note that cross-border data transfers was one of the top issues that everyone in this webinar is looking at. If you look across all the various mechanisms for cross-border data transfers, when you're looking across horizontally, you will see that not a single one of them is accepted throughout all these major jurisdictions, right? The ones that are perhaps most common would be an assessment of another jurisdiction's data protection laws, or what we call adequacy. Consent is another one, and perhaps third in line would be certifications. But there are unique aspects. If you look at the vertical, which is under Vietnam, they only recognize one mechanism for transferring data outside of Vietnam, which is through filing a security assessment with the regulator. Similar for Laos, they only accept consent. And then when you look across to, say, China, which is the first vertical, you see that they accept certification, they accept security assessment. I think they also accept standard contractual clauses, but there are also exceptions for things like necessary data, core data, important data, that comes in. So it really is a very, very complicated picture. So that really keeps us awake at night, keeping track of all this. One way to kind of read this is not just to look at the laws in isolation, to look at what is on the statute books now, but instead to look at what the regulators are focusing on. So that's where I prefer to turn to next. So Marie, if I could ask you to go to the next slide. To help stakeholders navigate this complex landscape more effectively, FPF APAC has released a report at the end of last year, focusing on key strategic priorities for the data protection authorities, or DPAs, in APAC in 2025. So we focus on 10 jurisdictions that have operational DPAs, namely Australia, China, Hong Kong, Japan, Malaysia, New Zealand, Philippines, Singapore, South Korea, and Thailand. And you can scan the QR code for that report right now. This report is one of the first comprehensive analysis of regulatory strategies and enforcement priorities across these 10 jurisdictions. And they show how DPAs, or the regulators, are responding to rapid technological change while trying to balance between innovation and privacy protection. So next slide, please, Marie. The report identifies several shared priorities across the region. And again, bear in mind that this is a very diverse region, but nevertheless, regulators have found common cause in 5 of these areas. 90% say cybersecurity responding to data breaches. 80%, so sort of aligned with the poll results earlier, focused on frameworks for cross-border data transfers, 70% emphasizing AI governance, 60% on biometric data, 50% on children's privacy safeguards. So let's jump into each of these shared priorities in more detail. Perhaps I'll pay more attention to data breaches, to cross-border data transfers, and AI governance. So next slide, please, Marie. Now, when we talk about cybersecurity and data breaches, we know that in this region, there has been a rapid evolution of digital technologies and the rapid adoption of digital technologies as well. Most, if not all, governments in this region look at the digital transformation as one of the key enablers or they look at the digital economy as one of the key enablers of their national economies. So these technologies, they drive innovation, they drive efficiency, but they introduce new vectors, new digital attack services for organizations in this region, because organizations are now managing vast data ecosystems spanning multiple technologies, jurisdictions, and third-party relationships. So it's not surprising then that cybersecurity and data breach response has been the top priority among all APAC DPAs. Now, what sort of trends are we seeing? Well, first, we are seeing a clear shift towards mandatory data breach notification frameworks. We have jurisdictions like Australia, Singapore, New Zealand. They've already established such schemes. And jurisdictions like Malaysia and India are in the process of implementing new requirements. Even Hong Kong, which was in the first phase of data protection laws, they're looking to introduce similar requirements through legislative amendments. So you can see that there is a growing consensus amongst the regulators that timely breach notification is important for individual privacy and broader ecosystem resilience. The second point to note is that enforcement approaches vary differently across the region. Singapore's regulator, the PDPC, and South Korea's PIPC tend to take a more assertive stance. They impose significant financial penalties for security failures. Singapore, for example, has been issuing some of its largest fines to date in response to inadequate security measures, and South Korea has imposed penalties exceeding US $11 million for data breaches on multinational companies. Whereas other regulators like Japan, they typically favor a more graduated approach. You start with guidance, then you go to recommendations, then you move on to enforcement action. The third is we're seeing increased regulatory focus on proactive security measures beyond just breach response. So you need organizations to conduct regular security assessments, to implement comprehensive data governance frameworks, to have detailed incident response plans and clear accountability structures, right? So the takeaway for everyone here is that you should go beyond data breaches just as a mere compliance issue, but looking at it as how to build digital trust with your consumers and trust with the regulators as well. Next slide, we'll move to cross-border data transfers. Today, we know that digital technologies, they transcend national boundaries, right? You have cloud computing, distributing data across global data centers, AI, you need it to be trained on data that comes from multiple jurisdictions, and even your routine business operations, checking on whether your warehouse has enough stock, right? Or making sure a payment goes through several payment systems. That could go through multiple jurisdictions, even in a single transaction. So because of this technological reality, 80% of regulators prioritize cross-border data transfers. You have jurisdictions like China and Thailand taking proactive steps to operationalize their transfer frameworks, and then jurisdictions like Malaysia and South Korea recently updating their frameworks to align with, perhaps one might say, international best practices. We are also seeing increased regulatory attention to the practical challenges. Japan and Singapore, they are pursuing mutual recognition of data protection frameworks and international certification systems like the global CBPR, which I think Mark will be touching on in a bit. Singapore has also been developing ASEAN, which is the Association of Southeast Asian Nations, ASEAN level guidance on cross-border data transfers. They map these model contractual clauses that ASEAN has to standard contractual clauses in the EU and in the Ibero-American Data Protection Network. Now, the final point to note is that cross-border data transfers, the regulatory landscape is really changing very rapidly. To give you one example, many of you mentioned India as a jurisdiction of focus. Many of you saw, if you've been keeping track of what's been happening in India, in coming up with their data protection law, which is the DPDPA, the Indian government moved from drafts containing a blacklist approach to a whitelist approach to a blacklist approach to a completely free flow of data approach. And everyone thought they folded their hands and said, okay, so it looks like cross-border data transfers is going to be fine in India. Next thing you know, the implementing rules that come out in its draft form say that for significant data fiduciaries, which is large data controllers, essentially, the government has the right to impose data localization measures at any point in time. So it was a sudden shock to the system. And that just goes to show that the landscape is rapidly transforming. Now, I'll quickly move next to AI governance, right? How are APAC regulators responding to things like generative AI, agentic AI? Some jurisdictions have developed innovation-oriented frameworks. You look at Singapore, for example, they are focusing on the Model AI Governance Framework, recent guidelines for generative AI. They also focus on AI Verify, which is a AI governance testing framework and toolkit, and then measures like a generative AI sandbox. Other jurisdictions, they focus on direct regulatory interventions. I'm looking at China. I'm looking at South Korea. South Korea has established a detailed AI governance strategy. They have, several measures, innovative measures that try and balance between innovation, AI innovation, and privacy. And we're also seeing regulators focus on practical implementation, providing guidelines. Hong Kong is doing that. Japan is doing that. New Zealand and Australia are doing that. Now, there's been two notable evolution in regulatory approaches in recent months, and I'll share both with you. The first is hard regulation of AI. South Korea has come up with an AI Framework Act. A few months later, Japan came up with an act that focuses on industry promotion, AI industry promotion, and R&D. Um, I think just last month, Vietnam passed a law on digital technology industry, which has a component of AI governance as well. We are seeing regulations that focus on omnibus AI regulation, but basically providing enabling mechanisms to provide regulatory agencies with the power to promulgate rules whenever it's needed. It's almost kind of like allowing the regulators to start from a starting block. And we are seeing this across various APAC civil law jurisdictions. So that's a pretty interesting observation that we are seeing. The second thing is the rise of more powerful AI models that are developed in this region. One example being DeepSeek, but I think there are other examples coming up as well. Regulators coming up with enforcement measures, like South Korea, for example. They banned the use of DeepSeek in South Korea for a couple of months, ostensibly on cross-border data transfer concerns and concerns about local data processing of personal data by DeepSeek, right? So we are seeing regulators grapple with not just data protection and AI regulation, but also concerns about national security, cross-border data transfers. I think these are two powerful themes that are coming into the space of AI governance in this space as well. And really, data protection regulators are in the thick of it. Now, I'll move on to slides, Marie, if I may. So jumping past priorities 4 and 5, we'll go to the next one. So I wanted to just touch a bit on how organizations should really balance, right, between innovation and data protection in this region. Well, the answer is you don't. It's a misnomer to say that you want to strike a balance. It's not technically wrong, but I argue that it's better to see it as mutually reinforcing. It's a virtuous loop. Because as you innovate, there will be more demands for protection. And the more you secure and the more you act responsibly, the more room there is for innovation. So I use the example of an F1 car. F1 races are pretty big in Singapore. In F1 cars, in order to go faster, you first need bigger brakes. And I think that's the dynamic that you want to see in this region. So how do you do that? I think striking this balance starts from the top. You need a culture that values innovation and protection, sees them as mutually reinforcing. You need clear, consistent policies across the organization, and these need to be properly understood in context by employees. You need to evaluate and assess the regulatory landscape to adjust to new business and regulatory needs. On the technical side, right, it starts with having a clear data inventory so that you know what data your organization is processing, is collecting, and for what purpose. To conduct risk assessments on that data inventory so you know what are the legal, the reputational, the financial risks that you are carrying with the data that types that you have. Effective protection controls, I think that goes without saying, and also considering privacy enhancing technologies. I know CIPL has a great paper on pets. And I think that is a technology, an area of technology that actually this region is starting to increasingly look at, right? You have Singapore, South Korea, Japan, Philippines, all looking at privacy enhancing technologies. So I think let's round up. I have a minute and a half left, and I don't want to exceed time. So we'll go to the last slide, please, Marie. I want to give you a sense of the predictions for 2025, right? These are where we think the regulatory attention will continue to develop in the rest of 2025. We'll see the continued development of AI governance frameworks. I've already mentioned Japan, Vietnam. We may see more jurisdictions coming up with similar enabling AI governance or AI regulatory regimes, right, in this part of the world. And in that sense, APAC is really striking off on its own in a different tangent from what the EU is doing from what the US is doing. And we will see more coming as well because India, they're going to be hosting the AI Impact Summit in February next year. So you can expect that there will be more to come in terms of AI in this region. Cross-border data flows will remain central to regulatory strategy. You will see jurisdictions like Singapore and Japan continue to push on trusted data flows, especially through mechanisms like global CBPRs. You will have other jurisdictions like Indonesia, India, and Vietnam showing renewed interest in data localization measures. But at the same time, developments in outside of APAC will influence APAC dynamics. One example is the US recently billing data transfer mechanisms in South Korea and potentially even in India as trade barrier mechanisms. So mechanisms that stand as trade barriers. With the whole debate and discussion about tariffs and trying to lower that, that could be used as a bargaining chip as well. And so you could see dynamics kind of change in the region in terms of how much the jurisdictions will think they want to prioritize data localization, protecting their own data storage ecosystem. You'll see that changing, and we can't predict. All we can predict is that there'll be change. Where it will go, we're not too sure. Third, we'll see the continued implementation of data protection frameworks. Again, I think that's a priority of many of you. Places like India, Indonesia, you will see jurisdictions like Australia and Japan update their laws. Vietnam is implementing their new personal data protection law as well. So it's going to be a busy space. I think the last one is youth protection, right? It's emerging as a dark horse key priority because of things like because of the intersection between privacy and online safety and even generative AI, right? You have Australia's proposed social media age restrictions that bring in age assurance issues to the picture as well. So I think youth protection, children's privacy is going to be another issue. So really, if you're an organization in APAC, success will depend on having flexible compliance frameworks that can deal with an increasingly complex digital ecosystem. So I'll pretty much end here. I think I'll just end on a final line, which is that the path forward, I think, lies in collaborative approaches, be it in AI, in cross-border data transfers, or in emerging tech regulation. Organizations and regulators need to recognize both the regional diversity of the APAC region and our shared interest in creating trustworthy digital ecosystems. So I've tried to go through this whole APAC whistle stop tour by not throwing you the rule book to go and read or the kitchen sink, but instead to give you a sense of the trends in the region and how you can start to see some of these developments in context. I hope this presentation has been helpful and look forward to discussions with you later and looking forward to Mark's presentation as well. In the meantime, Joanne, back to you.
All right. Thanks so much, Josh. This was really great. And a lot of the trends and even the predictions, I feel like these are universal. Where, we're seeing this across, different regions, these similar types of focuses, and I know you didn't really get to touch upon, the trends around like youth privacy and biometrics, which is something, we're seeing here a lot in the US. Mark, does this align with, some of the observations that you are seeing in terms of regulatory trends and, where things are headed?
Oh yeah, definitely. And thank you, Joanne. I gotta give a shout out to Josh. I mean, that was an amazing presentation for
I
somebody
know.
after 10 p.m. at night. So kudos to you, Josh, for giving us that great whistle stop tour.
And with that, Mark, I'm going to hand it over to you to talk about, the global CBPR forum, the data transfer mechanisms, and let's dive in.
Okay, thank you very much. To give everybody a background, and first off, why we're actually talking about this, as Josh mentioned, that data transfers are a significant part of the modern data economy. So if you're doing business in the Asia Pacific region, you should definitely be aware of the updates to that region's data transfer mechanisms. So traditionally, APEC formulated the CBPR, which is the cross-border privacy rules. and the parallel framework called the PRP, the Privacy Recognition for Processors. So the CBPR addresses what controllers do with information, and the PRP obviously with what processors have to do with it. And these were first developed by the Asia Pacific Economic Cooperation back in 2011 and 2015, respectively. And they were based on the 9 privacy principles set forth in the APEC privacy framework. So they're pretty high level principles like preventing harm, notice, collection limitation, choice, integrity, security safeguards, and a few others. But there was basically very high level privacy principles that they implemented in what they called program requirements. Now, in 2022, the 9 APEC economies that were participating in the APEC CBPR system established a global CBPR forum for the purpose of expanding both CBPR and PRP globally to address interest from jurisdictions outside of APEC. So it's no longer just to be viewed as a regional transfer mechanism. So the forum was established to share and promote best practices on privacy and data protection, as well as to promote interoperability with other data protection and privacy frameworks. And these objectives are outlined in the 2022 Global CBPR Declaration. So currently, jurisdictions can participate in the Global CBPR Forum as either members or associates. And the membership versus associate depends on their level of readiness to operationalize these systems. So the 9 current members are the ones who are part of the APEC framework, and that would be Australia, Canada, Japan, Korea, Mexico, Philippines, Singapore, Chinese Taipei, and the US. We currently have a few associates in the Global CBPR Forum. They're Bermuda, the Dubai International Financial Center, Mauritius, and the UK. And other countries have publicly announced their intent to join the forum. They're not officially associates yet, but that would be Nigeria and Thailand. So you can see that we are not totally just in the Asia Pacific region. We are expanding elsewhere, and that's the idea to provide a truly multilateral transfer mechanism for organizations. Next slide, please, Marie. Okay, so just to give you a high-level overview of how this all works, the global CBPR and PRP systems are what we call certified compliance programs that help facilitate trusted personal information flows. But you have to be part of a participating jurisdiction, the ones that I mentioned, and you have to be a certified organization. So what's important to note here is that these systems are able to coexist along other transfer and due diligence mechanisms. They don't replace like model contractual clauses or standard contractual clauses or BCRs. There definitely are contexts where those mechanisms make sense and they may be more appropriate and effective. But because of the multilateral and flexible nature of global CBPR and global PRP, their utility will increase as the number of jurisdictions and certified organizations grow. So certifications ensure that organizations have implemented practical measures, which we call program requirements, that fulfill baseline data protection and privacy requirements. So for example, do you provide notice in a certain way about what your privacy policy is? Do you provide an opportunity for individuals to correct their information? Those sorts of very detail-oriented elements. Now, as I mentioned before, the Global Forum itself is the entity that is comprised by the participating jurisdictions, and they're charged with the administrative, operational, and oversight functions with respect to the systems. But participation by the individual jurisdictions is foundational to the operation of the systems. And since the Global Forum is actively seeking participation by jurisdictions worldwide, any jurisdiction may now apply for forum membership by accepting the principles and objectives of the Global CBPR Declaration and Framework. And also by demonstrating what we call a mapping exercise of how their domestic legal system enables enforcement of the program requirements. And CIPL has been involved in the past helping various jurisdictions to do that exact mapping exercise, where we take a look at what the actual program requirements are, and we look into the given jurisdiction's privacy law or other laws, and see where they align, how they line up.
Yeah, and Mark, and you mentioned that the UK has joined as an associate member. What exactly does it mean to be an associate member?
To be an associate member means that you have the intent to become a full member in the forum, but you're not quite ready for a couple of reasons. Maybe you don't quite have alignment yet in your local law to align with the program requirements in the CBPR. Alternatively, maybe you're waiting for the global CBPR to add additional requirements, which is actually what's going on now. Some jurisdictions have been hesitant to join the global CBPR because they have in their own local laws certain requirements, for example, like data breach notification requirements, that are
Mm-hmm.
not currently part of the global CBPR system. And so the forum is now evaluating topics like that, like data breach notification, to formally incorporate that within the global CBPR system. That might make it more attractive for other organizations or other jurisdictions to join the framework.
Right. And what about the EU? Have they shown any interest in this particular framework or thinking through how this could be interoperable with their approach to data transfer?
The EU has sent representatives to workshops in the past. I was just at the Global CBPR workshop last month in Singapore, and there was a representative there from Germany willing to look at the global CBPR. Conversations are ongoing. I know that there is an effort to host a future global CBPR workshop within the EU so that we can make it a little more flexible for EU member countries to learn a little more and to understand what the framework is, that it's not a replacement for anything that's already in place, but a supplemental measure to be used by organizations to help facilitate global transfers.
Right. This is just another powerful tool for their data transfer toolbox,
Yes,
right?
yeah. So
Yeah.
it's definitely we're going to keep moving forward. I say we. I'm not part of the forum. I'm an independent observer, but I like to use the royal we from time to time. Okay, if we go to the next slide, and I can finish up kind of the overview of what all of this is. So in the framework, I'm sorry, I'm finding my correct notes here. Domestic laws and regulations provide participating jurisdictions with a legal basis for enforcing the system. So it's not so much that that the program requirements themselves are enforced by any independent party. It's actually by the local privacy enforcement authority, like the ICO, for example, in the UK, or the FTC in the US. That the participating jurisdiction must have at least one privacy enforcement authority to enforce the program requirements based on what the local law says. And that relates back to the mapping exercise, which I mentioned earlier, that part of that exercise is to find the elements in the program requirements within the local law so that the local law enforcement organization can enforce the program requirements. Now, an important part of this whole scheme, and something that I know is near and dear to Joanne's heart, is the role of the accountability agent. Okay, so an accountability agent is an independent third-party certification body which assesses whether an applicant organization can be certified by satisfying those program requirements. And I know, Joanne, that TrustArc is a recognized accountability agent, and that you do provide this service for organizations wishing to certify.
Uh,
If you want to
Yes, we do.
jump in here.
We've been involved since the early days of developing the Apex CBPR system. So we were the first recognized accountability agent under that system in 2013. So as the global CBPR and PRP system was being built, we've been involved with that, and of course, we are a recognized accountability agent under this system as well. So it is a very the role of the accountability agent and the certification, which Mark is going to touch upon, is what makes this system unique from other transfer mechanisms, and really provides a level of accountability for this particular mechanism. Mark, just real quick, as they were touching upon, as you were touching upon the requirements, has Simple done a mapping between the CBPR requirements and the EUS data privacy framework, and kind of where are you seeing overlaps?
We did, but that was not published externally. We did an internal exercise to that extent, so we're not really ready to reveal what we've seen there. The requirements, maybe I should put it this way: the issue with the EU is more to deal with the requirements of the GDPR versus the actual DPF framework. Okay, because it's ultimately what the requirements are in the GDPR, and we have done a mapping of that, and that is available on our website if anybody wanted to take a look at that.
Great, great, thank you, Mark.
Okay. Yeah. So basically, just to round out this slide, so any organization that's here in attendance who is interested in seeking certification would work with an accountability agent like
TrustArc.
TrustArc. Okay, yes, TrustArc. Go for TrustArc. And TrustArc actually works with the organization, starting with the self-assessment of the policies and procedures that you already have in place within your organization. And to the extent that your current policies or programs fall short, then TrustArc or another accountability agent can work with you to help you, get into a place to be compliant with the program requirements. And certifications currently are subject, I think, to annual attestation and recertification, right? That
Yeah,
may change, though, depending. There was discussion of that at the global CBPR workshop. They may extend that term, but that remains to be seen.
yeah, currently it's annual.
It's annual now. Okay. But one notable thing, as far as consumers, the individual whose personal information we're protecting, the systems do provide complaint and dispute resolution mechanisms for consumers. That's part of the requirement, that internally an organization must have such mechanisms in place. And that is a benefit for consumers in the long run. Next slide, please. Okay, here is a basic overview of what the systems look like, from the company's perspective, right? So the company is the one who is seeking to have a certification mechanism, so they work through to the accountability agent, who helps them assess their policies and practices. And if their policies and practices, where the equal sign is, align with the program requirements, then you can get certified. The part that the company doesn't have to be involved in is the part in that kind of tealy green thing that has to do with the individual jurisdictions, where they have to make sure that their local law is aligned and enforceable by the, we just lost the slide deck there, but where they are aligned and enforceable with the program requirements. And that enforceability is by the local data protection authority. All right, so what are the benefits? Why are we promoting it here? Why should you know about this? Number one, know that this is voluntary. Okay, you're not required to do it. It's another tool in your toolbox, in your data transfer toolbox. If you want to embrace something that is multilateral, that will work between and among jurisdictions, then this is the way to go. The standards within the framework are enforceable by the data protection authorities themselves. Okay, so it's not like what do you call, like an industry standard with just kind of self-enforcement, but these are enforceable by the local authorities. And it's flexible because you can tailor them to fit whatever your needs are within your organization. I mentioned earlier that it's a multilateral recognition, and it will, as it gains more members, it'll increase in its importance and its use. All of these are accountability based, right? So if you say that you have these elements in place, you're held to that. You must be accountable to make sure that you are complying with the requirements. And as I said earlier, that these coexist with other transfer mechanisms. They're not a replacement for BCRs or SCCs, but just an additional tool that you can use. Okay, next slide, please. The benefits for jurisdictions, and as you can see from the new jurisdictions that are inquiring into it, it does facilitate secure and trusted flows, but it also boosts the local economy, especially for data processors who are located within these jurisdictions. So it kind of gives them an opportunity to have new business coming to them. And it also helps the jurisdiction's enforcement authorities because they can kind of pick and choose only the most severe violations with the use of the accountability agents and the internal controls that organizations have in place. The less intensive, less risky complaints, that sort of stuff can be resolved at closer to the issue. You don't have to elevate everything to the data protection enforcement authority. The benefits for businesses is this compliance facilitation. The framework itself is basically a compliance framework, so it helps you ensure compliance not only with your local law, but with the laws of other jurisdictions that are part of the framework. There are now trust marks. The global CBPR has actually issued some trust marks for data transfers so that folks in the business community can recognize companies that have this mark. And I unfortunately don't have a picture of what they look like, but I'm sure Joanne can show what they will look like. And it also supports smaller businesses because smaller businesses don't necessarily have the resources in place to support a full-blown privacy compliance program. But because the program is already kind of made part of the framework, that if all you have to do is follow the framework, then you are in fact implementing a good privacy program. For the consumers, as mentioned before, there are internal compliance mechanisms already put in place so that they can lodge complaints and resolve disputes. And it also obviously enhances data protection for consumers themselves. Before I move on to the next topic, I wanted to see, Joanne, if you have any additional comments about the global CBPR, or if anybody had any comments from the audience.
No, thank you, Mark. And Josh, thank you for adding that link into the webinar chat to show an example of the global CBPR seal. And that is one of the nice things about this system is that there is a consistent branding across the entire system and all the accountability agents that, it's a recognizable seal by consumers, by regulators that, this particular organization has met a core standard of data protection requirements. Now, it doesn't replace the requirement to an obligation to comply with the laws within the region, but is a excellent way to show that you have that core base data protection measures in place, and especially if you're a data processor, it is a signal to data controllers looking to engage with vendors having those trustworthy practices in place. So it really does provide a lot of value, and that value is going to increase as the system grows. And as Mark mentioned, a number of jurisdictions are very highly interested in joining this system.
Yeah, and just to that point, I know you probably have mostly a US audience here, but I'm sure there are a few organizations from Canada, and Canada actually does not
Yeah,
currently have any accountability agents, but it now has a consultation open that closes, I believe, at the end of this month, that showing their intent that they're going to move forward on this and what accountability agents would look like in Canada for any folks based in Canada out there. So just to let you know, things are moving forward, even within jurisdictions that are already part of this system. And
yeah.
I apologize greatly because I say I have all of 3 minutes left to go through a very complex rule. If we could move, and I'll only highlight it from a very high level. Marie, if you could jump 2 slides ahead to the DOJ bulk transfers rule. Why did I want to raise this? Because this is a very significant update to data transfers in the Asia Pacific region, especially to China, because this new DOJ bulk transfers rule is an extremely complex regulatory regime that restricts the transfer of US personal and government data to certain countries and persons of concern. And of course, China is one of those countries of concern. So this implements an executive order that's from the Biden administration, one of the few executive orders that was not revoked by the Trump administration. So you can see how important this is. And I just, in the couple of minutes, because I know I can't get into it, but these slides will be available to you after this webinar. But I just want to highlight how data itself is not just viewed as an economic driver, but also as a strategic national asset. And this is why the US government is now involved in this space. CIPL held a recent In Focus event earlier this month in New York, where we had a group of senior level privacy professionals, and they really discussed the need for privacy leaders to understand the nuances of this new strategic national asset, data as a strategic national asset, and to adjust their roles accordingly. So you need to, as privacy professionals, understand the intricacies of this new DOJ rule, and it's horrendously intricate. And I will very quickly just roll through the next slide just to let you know, there are four key terms here, like who's a US person, what's a country of concern, who's a covered person, and what's a covered data transfer. So a covered person, of course, would include entities organized solely under the laws of the US or any jurisdiction within the US, okay, not just US persons. So if a company is organized under US laws but has a foreign branch in a country of concern, that company, including its foreign branch, is a US person, okay? Country of concern, as I mentioned before, includes China, but it also includes the Special Administrative Region of Hong Kong and the Special Administrative Region of Macau. Covered person is I'm sorry, it's 11 o'clock and I know maybe I should just end it here and say, take a look at these slides. I know that my colleagues at Hunton recently did a webinar, on a very in-depth webinar on this very topic, and I encourage you to reach out to view a webinar that was recorded by Lisa Soto and her team on this very topic. It's extremely complex, extremely nuanced, and they are much better qualified to to discuss the intricacies of this rule. But just be aware of it, and if you haven't already taken a close look at it, and you are dealing any business at all within China, you better take a look at it. Okay, and I apologize for the time limitations.
Oh, no, and Mark, we covered a very important topic around global CBPR, and Roy, appreciate you doing the deep dive to help educate our audience around that. And I agree, the DOJ rules is a very complex topic. It could be its own webinar, so I do encourage you, as Mark noted on the Hutton website, to take a look at that because this is an important set of rules to note. And with that, I do want to thank all of you for joining us today, and a huge thank you to Josh, especially since he is up late in his evening, and also to Mark. You both have presented our audience with a lot of great information, great overview of what is going on in the APAC region in terms of the laws, the regulatory trends, and then, the global CBPR system and how that is going to really enhance companies' data transfer mechanisms, and touching upon the DOJ rules. And again, thank you. Have a great day.